Good morning and welcome to the Hall of Justice for our May oral arguments. We will call our first case, Pinebrook versus the City of Warren. This is a 20-minute mini oral argument on the application. Welcome. You may reserve time for rebuttal, but we ask that you keep track of your own time. And you may begin when you're ready.
Well, good morning. My name is Alan Green, and I represent Happy Trails Group, Inc. and Blue Spruce Ventures, but I'm going to be speaking on behalf of all the plaintiffs and appellants. With me at the council table is my colleague Jill Wheaton and Jonathan Frank. And I would like to reserve 5 minutes for rebuttal. Well, thank you. This case involves, as you know, a majority decision of the Court of Appeals which reversed the trial court on an Open Meetings Act violation dispute, arguing that the review committee at issue here was not a public body because it was not a governing body. And as you probably noted when you read our brief, that it's our position that the Court of Appeals majority decision here would result in a significant change in the application of the OMA to government decision making. And contrary to the policy of open government and government accountability set forth in the OMA, these changes would create a hole through which a truck can be driven, and I will explain that. I am going to be talking very specifically about this government body issue, but I do want to make a few general comments. First, there's no doubt that there are governmental bodies that view OMA as a nuisance. And every once in a while, sometimes it's generational, this court or the legislature takes action to put people back on the right path. That happened 30 years ago in the Booth case, where this court ruled essentially that contrivances to avoid OMA will not be tolerated. And Booth served that purpose. It's been cited often in many OMA cases, and it is the basis of the factual analysis that most courts have dealt when they deal with OMA cases on the facts. The defendants here and appellees actually asked this court to limit OMA in 2 material ways. The first way is you don't need to scrutinize what actually took place in the case or in the situation. You don't need to focus on the function of the committee, who was on the committee, the reaction of the committee's work product by a arguably and clearly a governing body, but just look at the 4 corners of whatever document that was used to create that body. If there is a document, some bodies don't have an ordinance like in this particular case, and rely only and exclusively on that document. In that scenario, which I think is contrary to what all the courts have done historically up until this point in time, is that you are going to allow contrivances, you're going to allow situations where creative draftsmanship allows very significant decisions to be made in private and outside of public scrutiny. So what happened here, we said what happened here, but I want to remind the court about the facts, which the trial court found and the Court of Appeals did not disagree with. So what you had a situation here is that the city council drafted an ordinance, created a committee to investigate, review, and we assert, make a determination as to who should get a license for medical marijuana. They met.
Do we have to agree with you that they determined that the review committee determined that, or is it enough that they did the scoring and made the recommendation?
I actually think, my own belief when I've looked at OMA, and I've looked at OMA in many other states as well, that OMA applies to a public body that is empowered to exercise a government function. Government function is pretty broad. Not every public body exercises a government function, so it is exclusive to that. But government function includes a lot of different things. And it includes recommendations and studies. Because if I look at something like a planning commission, we all know a planning commission is subject to OMA. The statute says it's subject to OMA. Planning commissions do a lot of things, but they make important recommendations. And they're the ones for a city council or a township board that will, for example, do the public meetings, do the public hearings on zoning changes or special land uses. They utilize the consultants. They take, if there's testimony, they take the testimony. Then they give a recommendation to the township board or city council. Yes, we recommend you grant this rezoning request. The council certainly has the right to reject that. But in reality, I rarely in my career, 40 years, ever seen that happen, because that body that they charge to do that is doing all the important governmental work. It's doing all the investigation. It's not for the township board at that time to sort of say, geez, we want to look at what you did for the last year, and we're going to reevaluate everything. That doesn't happen. So
the Planning Commission, under your example, are they subject to the Open Meetings Act because that duty has sort of been delegated to them? What's your theory on why that Planning Commission should be subject to the Open Meetings Act? And I assume in most communities is.
Yeah, I think that the Planning Commission is subject to a separate statute. It's the
okay, so they have their own. Okay,
they have their own statute, so it's very specific there. But those are governing functions.
So here, is it the act of ranking that's the government function?
No, it's the act of selection. If you look at what happened here, and as the trial court says, this wasn't a ministerial function. The actual criteria that the committee was using were very subjective and policy-making criteria. Is this meeting our objectives for charitable contribution? There's just a whole bunch of them that would typically be policy-making decisions that the city council folks would make. So what's happening on this committee is that you've got a committee, and this is the critical distinction, and I think it's a critical distinction for distinguishing all the cases one from the other, is this committee was populated by the final decision makers. Even in the Davis case, with that whole long analysis that the Court of Appeals did on whether it was governing or not governing, the one thing that was clear is no one on that committee, the Financial Review Committee, was a decision maker. This case...
So is that where we draw the line? As long as there's one decision maker on a committee? Is that
no,
where...
No, I'm sorry. I didn't mean to interrupt.
Because I'm
Right.
thinking of a situation where a council can delegate...
Right.
truly delegate their authority that's
Right.
given to them and outlined in ordinance, and that what they delegate is decision-making authority, even though
Right.
it goes to the council for final approval. So where are we drawing the line?
I think the line. I don't think there's a bright line. That's why I'm saying they say don't look at the facts. I say you have to look at the facts, because what they did here is they created a committee. And they appointed 3 city council persons on the committee, which constitute the majority of the committee. There were no citizens on it. So city council members controlled the committee. They worked for 9-10 months in secret, determining, ending up putting out numbers that no one could ever, figure out what they really meant, on subjective criteria, policymaking criteria. 24 hours later, they crossed the aisle, so to speak, and they get to vote on what they just did without any discussion. So I guess what I'm trying to say is you have to look at what really happened throughout the entire process, from the beginning to the city council end, because if they put one more person on, if they put a 4th person on, it's not even a committee anymore. It's a quorum and it's a city council meeting.
Right.
And so
we could go, we could come up with all different compositions of the committee, just 2 people instead of 3. And I understand, that you're suggesting that there can't be a bright line rule, but we like rules.
I know you do.
And we want parties and the public to know what
Right.
those rules are. So I'm asking you, what is it that you're, not just for your case, but this case and going forward, what is it that you're asking us to say is the rule that is it if you have any member from the council in this instance? Is it the delegation? What the authority is that's given? Where do we? If we were drafting something? What would it look like?
The determination under OMA is whether or not they were empowered to make a government decision, and I think that the Court of Appeals construed that government decision to be too narrow. Bless you. They construed it in such a way as that you had to have a policy-making role. You had to make or enforce policy. And that's really not what a government function is. A government function could be, this committee is going to be charged with doing an investigation of a very controversial public situation, then they're going to report to us on that.
Respectfully, you're not helping us
Yeah.
get to the answer here. You just want to cut a piece of pie that takes care of your client, but we have to make a ruling that's going to apply to all the future cases. So
Right.
if the committee appoints a subcommittee and says, take what we've got here and just weed off half so that we only have to look at the top half, is that subject to Open Meetings Act?
Well, again, I don't think that the committee would have authority. Again, they're not empowered to create a subcommittee to do that. It'd be the same thing as what happened in, like, the Herald case.
Well, work
where,
with me and say they did.
Yeah. Well,
They did. No, is that open meetings?
if they did, then it could be open meetings. And I'm serious about this, and the reason I
That's
say
going to be a
that...
great opinion to write.
I'm serious about this because the performance of a governmental function, is and includes recommendations and studies. And yes, there are many committees. I mean, government operates through committees. I get it. I see it all the time. And those committees really don't have decision makers on them, and they come back and they make recommendations, and then the actual decision makers go over that, and they have their own obligations to deliberate in public. And,
So that sounds to me like what you're saying, not necessarily what they've been delegated, but who is who's serving on that body that has been delegated the authority. So like in this case, right, if there wasn't this committee, the city council would have to have done these things that it has
Right.
delegated to them, right? And so that's the theory, but couldn't that be the case in all sorts of things, right? Like the city council is responsible for determining whether their public parks have enough swing sets. Like, that ultimately falls on them. Could they delegate that? I mean.
Yes.
So it's not what necessarily they're delegating, even if it's something
Right.
that they themselves would have to do. It's what is the makeup of the body that you're delegating it to?
It's a combination of the makeup of the body, and it's a combination of what are the decisions being made. I mean,
But is it always, like, because it's pretty common in
Right.
municipal governments and school governments to have committees
right.
that are often made up of 2 or 3 commissioners. Are they all
Right.
subject to the Open Meetings Act, or does it depend on the work they're doing?
I think it depends on the work they're doing, and I'll give you an example. Just this morning, I was just curious about this. So I looked up Novi, picked Novi, a city, looked at their website, looked under government, what they consider to be government. They listed a bunch of committees, including the Planning Commission, Beautification Committee, and a whole bunch of other ones. And then if you look at each of those committees, every one of those are operated as a public body. They all issue agendas. They all have public meetings. They have call to public comments, and they all issue minutes of the meetings. So municipalities, or some municipalities, are treating these bodies that are actually doing government work and
But
given
they could be,
sign as
they could be doing that just
they could.
for transparency purposes, which is great. But when we look at
Right.
the statute, I think what we're all trying to get back to is,
Right.
what I'm hearing is that you're saying it's both. It's the makeup of the committee as well
Right.
as the function. So help us draw the line when we're looking. So if you don't have anyone from the council on the committee, not subject to the Open Meetings Act. Is that what you would argue?
No,
Okay.
not necessarily. Again, it depends on,
So is it one or the other? Is it both? Is it?
I know you're struggling with it the way I struggle with it. What the court below said, just look at the 4 corners of the document. What I'm saying, the 4 corners of the document matter, and I'll get to that in a second. But you can't just look at that. You have to look at who was on the committee, what was their decision-making authority, what did the actual body, city council, do? I've never seen anything like this in what happened in this case. 24 hours after this committee did its work, They went to city council. There were no deliberations. There was no discussion about the merits of anything on the records.
Let's assume though they did deliberate. Let's assume they took the rankings, they deliberated, they redid the rankings. They dug in, they spent 5 hours at a city commission meeting, and they redid the rankings in public. Would that have been, would you still have an argument that the original rankings were subject to the Open Meetings Act?
If the ordinance were properly drafted, I would say that they would have done their job then, but we haven't talked about the ordinance itself yet, so I want to get to that. But in this case, as the lower court found, that a very critical issue of public controversy and importance literally went from beginning to end to city council approval in the dark.
Seems like that happens in the U.S. Congress all the time.
That doesn't mean it's right.
Is it unconstitutional? Is it unconstitutional, or does the legislature or the Congress have the ability to make their own rules and decide how much time they have to deliberate? Or is it up to us to tell them that they have to deliberate for a certain amount of time before their work product is legitimate?
I don't think that we need to set a rule or any rule on how much time someone needs to deliberate or what the nature of deliberation was. I think you look at the overall course of conduct and there was no deliberation. And what happens in a case like this, forget the license applications here. There were people at that meeting that couldn't speak, that were normal citizens and business owners that would wake up the next day and find out next to my bookstore or drugstore I got a marijuana dispensary, and I had no idea how that happened, or had no idea, had no say in it. I didn't even get to express my views to city council. I mean, this whole process was intended to avoid public scrutiny from the beginning to the end. And so when we said in our complaint, we said not only did the committee violate the Open Meetings Act, but city council did too, because of the way it acted. So this concept is that you don't look at what occurred is contrary to this court's decision in Booth, because that's what this court did. It looked at Booth, it said, you know, you say you did all these committees, you were the decision makers, and while the university said in Booth, you know, when we got together at our one meeting, we could have done something different, because we had never voted before. We could have picked somebody else or gone back to the drawing board. That's what they say here. Well, it's not a quorum. You know, the city council could have done something different, could have picked somebody else, could have investigated it. They didn't do anything. I mean, it was clear. The chair, the representative, one of the representatives from the city council is on the committee, you know, makes a motion to approve the work product that he and his two colleagues did, because they controlled the committee, and then it got approved. That was it. So I think what's happened there is...
You have 2 minutes, a little over 2 minutes left, so
Okay.
if you want to reserve time,
Okay. There's another issue then, which I could talk a lot about, that I think needs to be considered by the court, is this other concept of restricting the Open Meetings Act by focusing on the definition of the word governing in front of body. Remember, our ordinance, I mean, our statute says a public body is defined as a governing body that's empowered to undertake a government function. And that's restrictive. But they're saying, no, wait, it's even more restrictive than that. Governing body also means something different. And governing body is not defined in the statute. And governing body, according to the Davis case, we're going to look at the Heritage English Dictionary, and we come up with a little definition of what a governing body is, which is inconsistent with the definitions of governing body in many other OMA statutes that define a governing body, and it's even more restrictive because that definition talks about that you have to make public policy. You have to be a decision maker with respect to public policy. That's where the decision making comes in. So I urge you to take a look at that. There's a lot there. And then the other thing that I would say in my last minute is that I think it's really important that we do not allow OMA to be characterized in such a way that it can be avoided easily by an ordinance like this. And you have to look at the ordinance here too. It's an ambiguous ordinance. On one point it says it goes to the committee for approval. And then later it says the committee sends something to the city council for recommendation. And in the court, no one reconciles what that means. I mean, no one's tried to do that. It's easy to reconcile it because what it could mean clearly is that the committee is charged with making a decision, a government decision as to who should get a license in that regard. And the city council, when it says after, it does talk about confirming that they've met the requirements, they're responsible for issuing the license. So, thank you.
Thank you.
Good morning, Your Honors. Andrea Pike on behalf of Defendants, Appellees, City of Warren, and the individually named defendants who are the 5 members of the Medical Marijuana Review Committee for the City of Warren. The issue before this court today is whether or not the review committee is a public body under the Open Meetings Act. It is our position that it is not, and that is how the City of Warren acted, and that is why the City of Warren conducted the review committee as if it was not a public body. Now, if you've seen in the timeline or the factual section of the briefs that there were public meetings by the review committee, that was based on a court order from the circuit court. But when those meetings were conducted, the review committee was very clear that it disagreed with the court and that it felt that it was not a public body under the Open Meetings Act. And it made that decision based on the advice of legal counsel, which was the City of Warren city attorney, which was not myself, but the city attorney. However, I do agree with his position. So when Mr. Green talks about looking at the 4 corners of the document, that is because that's what the Court of Appeals said in this case. And the Court of Appeals was relying on the Davis case. And it was very clear that you must look at the law that is giving or at least characterizing what authority, what power, what duties you have. Here, that is the City of Warren Medical Marijuana Regulatory Ordinance, which is attached to as Appellee's Appendix Number 1. Section 19.5-13 and -14 are the sections that need to be looked at, but case law is very clear that you have to read the ordinance as a whole. You cannot take pieces out of it and just look at that. As you saw, the Court of Appeals' partial concurring and dissenting opinion disagreed with the majority because it took a piece out of the ordinance. Mr. Green is saying because of that piece that's in the ordinance is ambiguous. But the ordinance and the process in the ordinance is not being challenged. It is not a legal issue that is before this court today. The legal issue is whether or not there was a violation of the Open Meetings Act, and to determine that, you have to look at whether or not the review committee was a public body under the Open Meetings Act. So first, you have to determine if it's a governing body. In order to determine if it's a governing body, which Mr. Green addressed, the language is empowered to exercise governmental or proprietary authority or perform a governmental or proprietary function. The power must derive from the state constitution, statute, charter, or ordinance, etc. Here it's an ordinance, and that's Section 2A of the Open Meetings Act. So when we look at the ordinance...
Counsel, can everybody avoid the Open Meetings Act by just creating these, whatever we want to call it, a body that makes recommendations, and then recommendations are brought forward to a city commission, and city commissions just adopt without any debate allowed? Is that, I mean, can that happen?
Well, Your Honor, here there was a debate, but if there was no debate, it comes down to the law, such as an ordinance, that delegates or doesn't delegate the authority. So it depends.
So everybody, they could just create ordinances for all the different things government does, the hard decisions city commissions have to make. Could they just pass ordinances creating committees, and then stuff could happen in the committee, and then they just can accept the recommendation?
If the public body, such as like a city council, is making a decision on a recommendation from that body, and the ordinance says that they're making a recommendation, then yes, they can do that, as long as there's not a quorum of the public body on the committee.
Where does making a decision, what you just said is the distinction, where is that in the language of public body? Because it says if it's any body created by ordinance empowered to perform a governmental function. Would you agree that what the Medical Marijuana Review Committee performed was a governmental function?
No, Your Honor.
Receiving applications, scoring them, making sure that they comply, and then providing them to the city council. That's not a governmental function?
It is not a governmental function.
Why not?
Because they were not delegated the power to make a decision on those actions.
Well, so you think governmental function is synonymous with making a final decision on them?
What goes hand in hand with being a governing body or having a governmental function is to make a decision or to exercise governmental authority, and you have to have authority from the ordinance.
Well, but the first clause says to exercise governmental or proprietary authority, right? So that's authority. Or to perform a governmental function or proprietary function, to perform a governmental function. So you're a public body if by ordinance you are a committee or a group or, any of those other varieties, to perform a governmental function. And so if receiving applications, reviewing the plans, considering their submission, rating the plans on a 0 to 10 score along with these factors, all of that is not a governmental function because it's not the final decision of who to grant.
That is correct, Your Honor. It's the city council that exercises the governmental.
What kind of function is that then? If it's not governmental?
It's being an advisory or recommending, it's making a recommendation. It's not performing a function. It's doing like the homework sort of for the public body to make the decision.
Does it matter who, as I think your opposing counsel is saying, it's sort of, you need both, that it depends upon who you're giving that to. So if you gave it to a 5-citizen member, 5 members of the public, and said, you receive these applications, you go through it, you do all this, and you give us that, it is, or
It's still not a governmental
it's still
function.
not, but even if you create a function where 3 members of the city council, the majority of this committee is the final decision maker, it's still not a governmental function.
Even though the majority of the committee is from the council, it's not a majority of council. It's not a quorum. It's a 7-member body. So 3 members being on the review committee with 2 city employees, it doesn't change the dynamics.
Well, we know that if they did 4, it absolutely
Right.
would be subject. So they did 3, maybe 2, maybe 1. Like, why, I don't understand why that's not a function, because if this body didn't exist, wouldn't the city council have to have done all these things?
According to the ordinance, the city council can have the review committee do it or hire an outside auditing firm.
Let's say the ordinance doesn't exist.
Okay.
And they're gonna grant, the city council's gonna grant licenses. They didn't set up this medical marijuana review committee. Who does the receiving of applications, reviewing them, ranking them, and just short of deciding? Who would do that? The city council?
Well, according to the the MMFLA, the city council can, or the municipality can create an ordinance to designate how that process will go forward. If there was no ordinance and there was nothing on paper how that would proceed forward, it is likely the public body would do it, but sometimes in municipalities, a city manager makes the decision, or a committee is created and acts as a public body, or it goes to an outside firm and then they make a recommendation to the public body, or here, a review committee makes a recommendation. So typically, it's outlined in a process and then the city follows that process, and that process is what determines whether or not the Open Meetings Act applies to what they're doing, what they're performing. They're scoring, they're reviewing, scoring, ranking, then they hand it off to Plant Moran. Plant Moran tabulates the scores, ranks them, and gives that with the applications to city council. So Plant Moran, an auditing firm, was hired by council, was not hired by the review committee, and so they were a piece of this process. It was the review committee and a representative from Plant Moran. Then city council made the final decision. And you talk about the word decision, and that is also defined in the same statute in Section 2A of the Open Meetings Act under subsection D. Public body is subsection A. And it says decision means a determination, action, vote, or disposition upon a motion, proposal, recommendation, etc. Upon is key because if you're making a recommendation, you're doing it so that the public body can act upon it. You're not making.
So you're proposing that there's a bright line rule that unless the council takes an official vote on something, anything else can happen behind the scenes and is not subject to the Open Meeting Act.
It depends what circumstances. So I'm not saying that council could go meet, in
Right.
closed session,
Yeah,
but
as long as there's not a quorum of the council, they can set up any other type of committee, anything behind the scenes that can do the work that you would expect to be done in the public and be subject to the Open Meetings Act, but they can just be clever and create all of these other things to avoid that.
Well, Your Honor, I would respectfully disagree because I think it doesn't matter. The determinative issue is not who is on the body. The determinative issue is what authority they're empowered with. Here we have an ordinance. If we didn't have an ordinance, we'd look at whatever law exists. But here we do have an ordinance that's very, very clear that says the review committee shall consider each applicant's submission and rate the plans and applications, forward the scores and application to the council with recommendations.
Yeah, but that ordinance is the
Yes.
council delegating their authority to a review committee.
With all due respect, Your Honor, that ordinance is the council keeping its authority. When it says the issuance of any provisioning center license shall be approved by the city council, which is section 19.5-14 subsection 1, they are retaining specific authority to make a decision. They are not delegating it. And their actions...
Well, they're delegating a big piece of it, though.
They're delegating the homework per se. But they have the applications themselves, the recordings, the scores. They can do their own homework, and some of them did before making a decision.
So that answer makes me think that the answer to my prior question of can they be clever and create things and delegate everything up until that, those final steps, right? All of the homework can be done behind closed doors, and it's just those final steps that they reserve for themselves. Is it fair that the way that you read the OMA, that they would be able to do that?
Under this ordinance. So if they're only making a recommendation and they're not saying, okay, we went through these 65 applications, here's one and they're terrific and they hand off the one. That's different because then the council can't look at the 65. And then it's a little bit more similar to Booth. But here, this is similar to Davis, where we give all 65 applications to council and say our recommendation is the top scoring applicants is ranked by Plant Moran. And Your Honor, I'm going to wrap up because Mr. Davis wants to have 10 minutes. But I just wanted to point out for the court that the city and the individually named defendants are seeking that this court deny the application for leave, and that is based on the appellants not setting forth a standard under MCR 7.305B, since this is not an issue of legal principle of major significance to the state's jurisprudence because it's very fact-specific. The Court of Appeals ruling is based on the City of Warren's ordinance, and it could not apply to other municipalities unless their ordinance is the same. And obviously, it's not clearly erroneous and will not cause material injustice. What the appellants are seeking is that this court change the law that was created in the Davis case and the Harold case, and that would go against, the rulings that are not erroneous. Thank you.
Thank you.
Good morning. My name is Robert Davis. I represent and arguing on behalf of the intervening defendants. We're essentially the group that was granted the licenses and then the OMA issue took over. I am not the Robert Davis, though, from the Robert Davis case. Just to alleviate that concern. I had a different argument ready for this morning because I really think that your question was pointed. You wanted to know whether this review committee is a public body. And I think when you look at the law and you look at the ordinance, it's clear they carved out and said, you are not a public body. You have no authority. You have no decision-making. You guys gave a definition of empowered in the list decision that I put in my brief. You defined what empowered mean. And empowered under your prior rulings means to give them official capacity to act. And here they did the opposite. They said you have no official capacity to act. But let me go to, because I think some of the examples,
Well, if they just show up on the day of a city council meeting and say, here's the recommendation, and the city council says, let's call the question, and they adopt in total, what is that?
well,
Is it enough that they took the vote in public?
but here's what we don't know as we're standing here today. All of the applications were in a room at City Hall. All council members had access to them. Has anybody?
So the answer is that it's not a violation?
No, yeah, that's my answer, because here's what we don't know. How many city
Isn't that the
council,
whole purpose of the Open Meetings Act, that you do know who went and looked at them?
well, they were available to all city council members. Who knows how much they studied? What you're getting into is, well, do I need to deliberate for 10 minutes and then it'll be official? Or do I need to deliberate for 3 days and then it's official? I have an issue. Very recently, I represented a community up in St. Clair along the water, and we got donated a park. So the city commission gets together and they say, well, what are we going to do with this park property? It's beautiful. So what did they do? They set up a committee, right? They set up a committee of one commissioner, a couple parks and rec folks, and some citizens to come back with recommendations with respect to what we should do with the park property. So here's the dilemma that we're looking at here. Under their position, every time there's a decision made by the public body on the recommendation of a committee, we're going to do a look back. Because what I'm going to have on the park.
Your other situation, I would call it hypothetical, but it sounds like a real-life situation.
It's real.
Sounds a lot like the situation in Morrison versus City of East Lansing. Are you familiar with that case?
I looked at the Morrison case. The Morrison case comes down to like a tie between
Morrison
Booth.
says that your situation, the advisory committee would be a public body with one member of
Well,
council as a
well,
liaison member. I'm
here-
just, before you say, well, do you agree with that? Is that what Morrison holds?
No, I don't think the Morrison case would apply to my situation.
So you don't even want to tell me whether that's what it holds or not? Is that what Morrison holds? I'm trying to understand. Do you know the holding of Morrison?
Yes, I do know the holding of Morrison. They
All right,
came
so-
to a tie and they said it was a public body. They got near the end of the decision and said it's a close call, but we're going to call it a public body, right?
Yeah, the holding is the building committee created as an advisory committee to assist in when a property was, I think, donated to the community, much like
Right,
your scenario
right.
is a public body.
Well, they held 19 meetings, 3 of which they made
Listen, I don't want
public.
to get into all the
Right.
ins and outs. It says that in this situation where there's an advisory committee that only made recommendations to the council, that was a public body. Mike, in the Davis case, the Court of Appeals distinguished Morrison. It does not appear to me that the majority of the Court of Appeals in this case addressed Morrison. The dissent addressed it in a footnote that I saw. And I'm just wondering, did the Court of Appeals, in your view, make a mistake by not addressing or even attempting to distinguish that case? What should we do with Morrison?
Well, I think in Morrison, the court, in my opinion, took too much time on the facts and too much time on the look back, and looked at how many public hearings they held, how much testimony they took, what did they actually do, and then decided it was a coin flip between being a public body and not being a public body. What I was trying to raise.
So you think Morrison was wrongly decided
Yes,
and should be overruled?
yes.
Was it a mistake for the Court of Appeals below not to address Morrison?
I don't think Morrison applied to this case because you have a clear ordinance here that depowered. If you look at the statute, it talks about the word empowered to carry out a governmental function. Here, they were depowered by not having decision-making authority. And in my case,
Just to be clear, so Morrison's distinguishable because it involved a resolution instead of an ordinance? Is that what?
no, I think resolution is in the list in the statute.
So why is Morrison distinguishable? I don't mean to interrupt, I'm just trying to.
I think it's distinguishable because they spent an inordinate amount of time trying to balance the facts of what happened, and then came to the end and said, that's enough to be a public body. But here you have a clear statute that tells you what is a public body. You don't have to drift at all.
What
You
if,
don't-
what if the ordinance had said, it's not a public body, but then in actuality, it hit the statutory definition of a public body? The ordinance doesn't trump that. They can't say, well, this is what we're gonna call a public body. This is one and this isn't.
No, they didn't do that. They stripped them, they did not empower them to perform a governmental function. The word is empowered. That's the one word we're not talking about a lot here. You have to be empowered to carry out a governmental function. That's in the statute. You defined what it meant to be empowered in a previous case called lists. I think it's at page 10 of
But
my.
aren't you conflating the definition of what is a public body with whether or not this public body made a decision and therefore violated the OMA? Empowered, which, as you said in lists, we said is given official capacity to perform a governmental function.
Correct.
I'm not seeing where that means make a final decision. It may be that this is a public body who didn't in fact make a decision such that it violated the OMA. But that doesn't necessarily mean it wasn't a public body, because they don't have to be empowered to make a decision. They have to be empowered, given official capacity, to perform a governmental function. And the function that they're performing, and I think your sister council said, is if this committee didn't do it, the city council would have had to have done it. And maybe they would have found a different way to do it. But ultimately, that function of receiving applications, ranking them, figuring out, scoring them, that ultimately is the function of this government in deciding who to give a license to.
What if they had the clerk do it?
What if, I'm sorry?
What if they had the clerk do it? What if the city clerk took in all the applications, went through the math, did the reviews, scored them, and sent them to city council? Would we be here now saying that's a violation of the OMA because the clerk did it?
Well, are we saying it's a violation, or are we saying it's a public body?
Well, I'm saying this review committee is not a public body. If you look at Davis, it talks about the independent ability to make a decision, to affect policy and effectuate public policy. So if you depower this committee, you are not empowering them to make a decision, and therefore they cannot form the basis of a governmental function because they have no authority. They've been stripped of authority. So could we have just hired somebody to tabulate these? Could the clerk and the clerk's staff do it? Could the clerk and the treasurer of the city have done this function? Let's say they did. Would we still be arguing that there's a violation, or that the clerk is a public body and should
Well,
have been?
maybe not. I mean, but that's a different case because you're talking about an individual officer, and
But
the
here's-
OMA
here-
defines them
here's
as a
the-
board committee.
Here's the slippery slope that I wanted to talk about in my little scenario of my park. What they're proposing is a look back, and you're going to be flooded with litigation because every time there's a disgruntled set of people in a recommendation that is adopted by a city government, there could be litigation. So if my little park committee says, we think it should be, what are those things called, those splash pad? And now I'm going to get sued by the manufacturer of swing sets because they believe it should have been swing sets, and they're going to cry that the committee violated the Open Meetings Act. I'm going to let you know right now, I represent a lot of local governments. We have a lot of committees, and we use them effectively, like the AG chimed in. The AG is, I think, on board with what I'm arguing. She doesn't want to see any changes here because they use a lot of committees at the state level too to carry out various tasks. But here you're going to have I think you have a bright line. I think you have a bright line with respect to the statute. If you now create a gray area where, well, it depends how long they deliberate on a decision. Well, it depends who's on the committee. Well, it depends what the function of the committee was. What you're inviting here is a lot of litigation because, take my park, turn it into a boat ramp, turn it into this. Any study done underneath a city government by a committee can now be challenged by the disgruntled people who weren't part of the recommended action that went to the city for final approval. And that's problematic.
Thank you. Thank you very much. Your time is up.
Thank you.
Thank you both. You used, nope, you used it all up. I tried to help you. I told you you had a little over 2 minutes left, so I apologize. Yeah, the case will be submitted. Thank you both. Thank you, all three of you.
Thank you.